We're going to go ahead and get started. Welcome to Anti-Harassment Training for Managers and Supervisors. My name is Melody Wingfield. I'm the Director of Leadership and Professional Development here at the city. And the reason that we're doing this training, we asked Chambliss Law Firm to come in and do this presentation because Kathleen, we're HR experts for you guys, but she actually deals with this in the courtroom and working with clients in matters related to harassment and discrimination. So she is like your expert here. The city spent a lot of money to do this training, and part of the reason it's so important, not just because we want to maintain a good culture here and prevent and address any situations of harassment and discrimination that happen, but as managers and supervisors, you can be held personally liable for the decisions you make regarding addressing harassment and discrimination and reporting it. You can actually be named in legal suits to where your assets are at risk in those decisions. So it's very important that you understand your responsibilities and how you need to respond to those things. And what you're going to be getting today is like real life examples of cases and situations that come up so that you know how this plays out in your world. So I'm going to let Kathleen take over from here, and please feel free to ask your questions. This is for you. You can see there's not a whole lot of people in the room, so if you have questions, this is the time to get the answers to those, and if for some reason we can't answer them, I'll be sure that we write those down and we get back to you personally.
Okay. Thank you, Melody. My name is Kathleen Siciliano. I'm an attorney at Chambliss, Bonner & Stoffel, and I work in the labor and employment section. So like Melody said, the majority of what I do is day-to-day providing advice and counseling to employers, managers on anything that occurs in that workplace. So that's the cradle-to-grave employment relationship that we're looking at. That's onboarding, interviews, job applications. Then we're also looking at if someone needs to take a request for leave, medical or otherwise. And then also if someone has a complaint of disability, discrimination, harassment. And then we also advise on the end of the employment relationship. So everything that happens in the workplace, we're able to be there to help you guys, including investigations and then also litigating those cases if that employment relationship ends on a negative note. So this presentation, like Melody said, really is for you guys. I've given it before. I know what it says. I know what I need to know. But you guys have this opportunity to ask questions, and it's much more interesting if you do ask questions. Because I know that you have real life situations and you've run into real issues as managers and as supervisors. So please ask those questions. Because at the end of the day, the goal that I want you all to remember, like one thing that should come out of this presentation is that you never have to see me again. Because if you have to see me again, that means something went wrong. So the goal, ask questions so that we don't have to have a phone call, we don't have to have a face-to-face. Something went wrong if you're seeing me in person again. We're going to talk about our employment laws, discrimination, harassment, retaliation, and how to effectively provide corrective action. I'm going to be providing you guys with 8 real-life situations of cases, questions we've received. What went right, what went wrong, what could have been better, how we could have prevented that situation, so that you all can use all of that as a learning tool. I do believe that you all have received just kind of like an introductory to anti-discrimination, anti-harassment presentation before. Yes, nod heads, otherwise Melody's going to send you back through it. Great. Okay, so I'm just going to run through all of this pretty quickly for you guys, just so we're all on the same page on some basic terms. First is Title VII of the Civil Rights Act. That provides protections to employees based on their membership in protected class of race, sex, religion, national origin, and color and religion. So an employee cannot be discriminated against, harassed, or retaliated against based on one of their memberships in a protected class. Americans with Disabilities Act, similar protections, but it covers an individual who has a qualified disability. So if someone has a disability that's preventing them from accomplishing one of the essential job functions, then they might need an accommodation so long as it's reasonable and it doesn't provide an undue hardship in the workplace, then they might be eligible for an accommodation under the ADA. We also have the ADEA, the Age Discrimination in Employment Act. That provides protections to employees in the workplace who are over the age of 40. But the inverse is not true. So if you're under the age of 40, you don't have those same protections under the ADEA. Only applies if you're over the age of 40. And then finally, the Family and Medical Leave Act. You all might be familiar with that one as well. That provides job-protected leave for up to 12 weeks, unpaid, for any individual who has a qualifying serious health condition. So long as they work for a covered employer, which they do, presumably at the city, then they might be eligible for 12 weeks of unpaid leave, so long as they have worked for the same employer for the past 12 months and have worked 1,250 hours in that past 12-month period. We're going to go over all of these in more detail. Just wanted to get a little bit of a baseline for us. So here are protected categories again. We have Title VII, which provides protections for individuals based on their race, color, sex, or gender. That includes sexual orientation, pregnancy, national origin, and religion. And then you also have our other legal protections. That's age, disability, FMLA, and then genetic information. I know you all don't have workers' comp necessarily, but you do have on-the-job injury. And then jury duty, as well as USERRA. USERRA provides protections to individuals who are in the armed forces and helps provide reinstatement, reemployment whenever they return. So we all have a certain number, a baseline certain number of protected categories that we're a member of. Does anyone know how many everyone in this room at least has? Maybe 4 or 5. So we all have a race, we all have a color, we all have a sex or gender. Not all of us can be pregnant, I don't think. National origin, we all have that. And then we all do have a religion or the absence of a religion. So we're all covered there. But we don't all qualify for protections under the ADEA because we're not all over 40. We don't all necessarily have a serious health condition or disability at this moment, though we could. And then our workers' comp, we could be injured at some point, we could be called out for jury duty, but at this moment, we're not all protected under those categories. So I said this at the very beginning, the number one goal that I hope you guys take away from this is that you never have to see me again. And to do that, I'm going to be focused on the defenses to employment claims. So what am I looking for when I get a call that you all have been sued, there's been a complaint filed, an EEOC charge has been filed? I'm looking for our defenses. How can I get us out of this? So surely whatever reason you had to terminate or to reprimand an employee, you did it for a legitimate, non-discriminatory reason. That is one of our main defenses that we're looking for. So you're not going to be liable for discrimination or retaliation if it was taken for a legitimate and non-discriminatory reason. Some of those examples could be based on merit or performance or seniority. So if you decided to promote one individual over another, what are your reasons for it? Are you looking at just, well, it was a seniority-based reason, or I was looking at the last 10 years of performance evaluations, or when you're hiring someone new, what was the reason for why you chose one applicant over another? I'm sure that whatever that reason is, it doesn't have to do with anyone's membership in a protected class. So hopefully we're able to articulate a reason that isn't just, well, they looked like they knew what they were doing, they were young, I wanted someone who was lively in the workplace, someone who was going to bring some like new blood into the environment. Okay, well, we might be looking at an age claim if all the other applicants were over the age of 40. So think about that whenever you're making a decision. what is the actual or true reason for the termination or the disciplinary action or that failure to hire. This is where things commonly go wrong. I'm going to go through 8 scenarios with you guys, and hopefully you all can learn from these on what not to do and maybe take away some key pointers on what you can do. So the first is, whenever I ask you all, okay, what is our legitimate non-discriminatory reason for this business or for this employment reason? I'm hoping that you're going to be able to send me the personnel file. And I'm hoping that within the personnel file, if you've decided that you want to terminate someone for poor performance, then within that personnel file, I'm going to see that. I'm going to see a record of poor performance. It's not just going to be your word against the employee's word. Where a lot of managers get in trouble is they don't feel comfortable enough providing that critical feedback to their employees. So rather than having the hard conversation with someone that you work with, you're not being completely honest with them. And when that happens, we get put into a situation where I can't point to the personnel file or the performance reviews that say that this individual was a poor performer for the past 4 years, and that's what supports the reason for termination. I had a situation recently with a client who called and he said, we have this employee, she's working remotely up in Maine, I work in California, that's where the business is located, and she's been with us for 4 years and her performance has just really declined. She's just been a really poor performer with over the last year. We've had a lot of conversations with her, and I just want to go ahead and terminate her. But I'm worried because she's an African-American female over the age of 40. And so we were like hitting 3 protected classes right then off the bat. And I said, okay, no problem. Go ahead and send me her personnel file and we can look at her performance evaluations and send me all of those corrective actions and documentation of all of the conversations that you've had with her over the past 6 months. And so I said, okay, let me look that up really quick. I'll look on the file on the system while we're on the phone. And so he pulls it up and he says, oh man, it looks like we gave her 5 out of 5s last year on the end of her performance evaluation. I said, okay, what about the years prior? He goes, yeah, she's been getting 5 out of 5s the whole time that she's been working here. I said, well, how is she going to know that she has not been meeting your expectations if at the end of every year you've been telling her she's been outstanding, not just meeting expectations, but going above and beyond 5 out of 5s? And he said, well, I think that her manager has been having these conversations with her over the past 6 months. Let me pull that up. And there's no record of it, of course. So we are going off of the word of the manager who says that she hasn't been performing well, even though this same manager is the one who for the past 4 years has been giving her glowing reviews. And he claims that he's been having difficult conversations with her over the past 6 months. I said, I don't think that this is the time to terminate her for performance-related reasons because she has no idea it's coming. And that's not what you want. If you're going to terminate someone for performance reasons, that is your legitimate, non-discriminatory reason for making this termination decision. They need to know that it's coming. They need to have some sort of inkling of expectation of what you wanted from them and that they have not been meeting that expectation. Because if they don't, then what else could it be? In her mind, she's an excellent performer. But what else is she? A Black female over the age of 40. She's a member of 3 protected classes right there. So she might be thinking, well, I have no idea what else it could be. It's just pretext. They're telling me it's performance. It has to be because of my membership in a protected class. So that's what I'm talking about up here when I say that I want to make sure that we have proper documentation so that I can look at it and support our claim whenever and if ever we have to get to that point. I had a good case one time where the manager had actually done a really good job with this. And the case was a female employee who worked for a male supervisor, and she wanted to get promoted to an executive level position. So she went to her supervisor and said she wants to make that application, wanted to see if he would be supportive of that. They had a long conversation, and he ultimately said, I don't think you're ready for this position. I'm not going to stand in your way, but I don't think you're ready for it. I'm not really in a position to support you. She said, okay, I understand, and they went on their way. Over the next month, her performance declined substantially. She, prior to that conversation, had been a pretty good employee, but after that, she all of a sudden was showing up late, not showing up, was going out for extended period of time to go get coffee and gossip with some of her coworkers, was spreading rumors around the workplace. She was complaining about her boss for the first time ever. She was just having a lot of issues with continuing to work there. So a month goes by, and our male supervisor goes to HR and legal and says, I think we need to have a conversation about her performance and what next steps look like. Whether or not that's a write-up or a verbal discipline, I'm not sure. That was on a Wednesday night. On Thursday, that same employee writes in to also HR and to legal, and she says that she feels that she's been subject to harassment in a hostile work environment at the hands of her male supervisor. And she wants to complain about him, and she doesn't feel that she can come back into the workplace until that has been resolved. So HR and legal meet with her, and ultimately she does not return to work, and she resigns next week. No surprise, she files a lawsuit claiming sex discrimination, hostile work environment, and retaliation, and a few other things. But during the course of our review, once we were involved, I had a sit-down conversation with the supervisor, and I said, have you documented any of her performance? And he said, yes, of course I have. I keep a OneNote, and for the past 4 years that she was here, I've documented every single conversation that I've had with her. Any instance that we had a disagreement or any instance where I had to have a verbal coaching with her, maybe it wasn't escalated up to HR, but I at least have a record of it, which was amazing. That never happens. And what's even better about OneNote, if anyone's familiar with it, every time you open it, it keeps a timestamp on the document. So it doesn't look like he just went back and dated things retrospectively after this complaint had been filed. We actually had timestamps of every time he had a conversation with her going back to 2017. Yeah, go ahead.
Just for everybody here, we're a Google shop here, so Google Docs does the same thing. We want to keep that in mind.
Yeah, which is great.
Nothing against OneNote, I love it.
Right, and to use that as an example, you can use whatever you want, whatever works best for you. So OneNote worked really great for him. I get the question a lot of, well, can I send myself an email? Yes, I love that idea because you're sending yourself an email at the time that the event occurs, and again, we have that timestamp there. Handwritten notes are fine, but if you're like me, you're gonna lose them. And then you're gonna forget to date them, or you're gonna forget some important piece of information in there, and it's gonna be more difficult to prove the authenticity of the handwritten notes because we don't actually have that built-in timestamp. The other good thing with email that I like to recommend is that even if you don't want to make a verbal or written complaint up to HR and document that type of corrective action, you can still copy HR on your email to yourself so that someone else has a copy of that and it could be in their file going forward. And you might not be that employee's supervisor forever. So if there's someone else who comes in as their supervisor after the fact, after you, then at least HR can catch that pattern of behavior. So those are two good examples. One, how an employee or an employer did a good job with keeping track of documentation. Another, how they did a poor job. And just keep that in mind whenever you're having those conversations with your employees. You might not always give them a written write-up, but I do always encourage you guys to send a follow-up email with them after you have a verbal conversation that just restates what you all talked about. You know, as we discussed today during our one-on-one, I really need you to be showing up on time more consistently because you've been late repeatedly over the past 2 weeks. Something like that. You can keep it casual. It doesn't have to be incredibly formal, but at least we have that paper trail. I will ask one more question. Has anyone in here ever been involved, either as a party or as a witness, into any sort of like employment litigation case? 1 person, 2 people, 3 people, 4? Okay. How long did that litigation last? Do you all have any memory or reference of how long that went on?
Months.
Months?
It was quick, months.
4 years?
Months.
4 months? Quick? Okay, you guys are lucky. Most cases can last anywhere from 2 to 3 years if we're in federal court. We had a case in state court here that lasted 9 years. I'll walk you through that process pretty quickly. So if we have a claim, is everyone familiar with the EEOC, Equal Employment Opportunity Commission? So if you have an employee who files a claim of discrimination, before they do so in state or federal court, they typically have to file it with the EEOC. So they file an administrative charge. They have 300 days to do so after the event that is leading to them filing that charge. So say 300 days after they've been terminated. They file their charge with the EEOC. It can sit with the EEOC indefinitely, really, but on average, it sits with the EEOC for 6 months. Once it sits with the EEOC for 6 months, then they issue what's called a notice of rights or right to sue letter. So the charging party then has 90 days to file a lawsuit in state or federal court. Once they do that, the lawsuit itself can take typically 2 to 3 years. So we're looking at close to the end of the lawsuit, the end of trial, to when that individual was terminated, we're looking at about a 4-year period. And if that's a jury trial and you all are the supervisor who did the termination, think about what you were doing 4 years from today, 4 years ago. You have no idea what was going on 4 years ago. I know I don't. And then you also have to think about, okay, that employee was with you for 2 or 3 years leading up to their termination. How are you going to remember everything that led up to their termination if you haven't kept some sort of record just for yourselves, just some sort of notes? Keep up with your notes so you can refresh your recollection as we're getting ready for your deposition or getting ready for trial, so we can talk about all of those things. Because what happens so often is that we have a supervisor who had a great reason for termination. And once we get to their deposition, you've moved on. You have lives. You have other things that are going on. You've kind of forgotten what really resulted in that disciplinary action or that reason to terminate them. So keep track of notes just for yourself, even if it doesn't need to be escalated up to HR, just for your own protection and to refresh your memory.
I had one that they actually resigned, and then like day 364, they filed a lawsuit they quit because they were being harassed. So you might want to make a note if you think somebody might be a little disgruntled when they left, because that was like, well, they quit, so hey, whatever. And then you go back and try to look back into that. But luckily, it only went on for months because they finally dropped it. But it was a royal pain just getting started. So
Yeah, it is, because I'm sure you saw a lot of attorneys during that time. It was interrupting all of your regular work day, had to interrupt all of your other employees' work days. It's a stress. It's a stressor that you don't want to have, and it's so much easier for you guys if you have all of your notes and you can just send them to me or send them to HR, send them to your attorney and just say, here, figure it out. Because I'm happy to do that if you have it, but if you don't, then we'll have to have long conversations. Any questions on personnel files and keeping track of documentation? So the next one that we run into quite a bit is misleading or incorrect performance evaluations. This comes up when a supervisor doesn't want to hurt their employees' feelings. They don't want to be completely honest with them. They are worried that giving them a negative performance evaluation is going to impact their promotion or their pay step for the year. So rather than giving them the honest 3 out of 5, they just go ahead and give them a 4 or a 5 out of 5 because they've tried really hard and you really don't want to give them a hard time. You know that they've had a hard year. That is only going to come back to hurt us. So, like I said on the last slide, it's so important to have documentation. It is only good for us if you were honest in that documentation. So, if you're not going to be honest in that performance evaluation, don't do it because it's only going to harm us in the long run. It's only going to harm the employee because they have no idea what their expectations are. They can't meet them if you don't tell them what they are. So be honest in your evaluations, not just for legal reasons, but for compensation reasons as well.
Okay.
Yeah.
Okay, so before she dives into this meat part, so everybody here participated in the growth and feedback conversations with your staff, where you had to ask the questions and had conversation, and that was kind of like a baby step towards us doing the performance evaluations, which those are coming. We're working on those right now about getting everybody on that system. It's not good for you to not be honest with your staff. And we're getting ready to, where everybody's on a step system now, so that there's steps there, where they're looking at tying the performance evals to the step system, to where you can recommend merit increases based on performance evaluation scores. And so, as managers, especially with inflation and everything being the way it is, we're like, oh man, inflation's high, we want to give our people as much as we possibly can because we want to help them out. But scoring people inaccurately leads to legal issues when they go and pull those files, and there's a problem, but all of your rankings say that there is no problem because you scored everybody really good. You're also not doing your employees a favor if you're not being honest with them. Because if you need them to perform here, and they're performing here, you are never going to get them to perform here because you're not even occupying the same reality as them. They think you're performing here, but they're not, if you haven't been honest. So you're actually cutting your legs out from under you by not being honest with your staff. And part of your role as a manager, how many of you applied for the job that you're in, right? You guys put in an application? Well, congratulations, you signed up for this. Being honest with your staff is part of being a manager. So please be honest with them for their own personal growth, to save you issues in the future with how you scored your employees, and also to make sure that they're growing and that they're performing where you need your team to be, because if you have a low performer on your team, who is taking up the slack? The rest of your team, right? So please be honest.
We have a lawsuit right now where we're dealing with this exact situation, and it's so frustrating from my perspective because I know that our client has been dealing with this individual for months and years and all of her poor performance issues. And one of the claims is that she was a poor performer, so that was the reason why we terminated her, our legitimate, non-discriminatory reason. Now she is claiming that during her last performance evaluation, she was promised a promotion because she was doing such a good job. She was going to be the next person who was going to be promoted. And when we look back at those year-end performance evaluations, her manager was just too nice, and he said it. He said that during her year-end performance evaluation of, yes, you're going to be the one that's up for that promotion next. Yes, you're doing a great job. Yes, we're going to give you a raise. And so that's part of her claim, is that it's undercutting our defense that she was doing a bad job. So please think about that whenever you're giving those evaluations, whenever you're having those conversations with your employees. I always think that it's really important to have those, not save them for the end of the year or save them for whenever you are doing merit evaluations and step-up bonuses, but have those conversations on a month-to-month basis. Your employees should know where they stand with you at all times. it should not be a surprise when you get to that end of the year. Any questions on misleading or inaccurate performance evaluations before we move on? No? Okay, the next one we have to talk about is harassment and misbehavior.
Excuse me, I have a question.
Oh,
Yeah.
I was just wondering if you all had recommendations on good resources for managers to tap into for how to have those difficult conversations.
We actually have training for that,
I thought you
so,
might say something.
you're new, aren't you?
What's that?
How new are you to the city?
Very.
Very new. So all the managers went through manager supervisor training, and there was a component in there about how to have critical conversations with your staff. So we are working on adapting that and actually being able to run another session where you can sign up for it and come actually practice it and how to have those conversations. Because it's more important for you to have those conversations before it's a problem than waiting until it's a big problem to go ahead and be meeting. That's part of the reason we did the growth and feedback conversations, is if you meet with your staff regularly, like quarterly, intermittently, to where you're constantly staying on top of the issues that they're having, what obstacles they're running into to being able to get the job done, then you pretty much are taking I'm going to be proactive instead of reactive. And a lot of times those problems don't even come up because you address them early. So I will get some information. We'll try and get something scheduled so that some of the new people can come back.
Question for you
Yes.
also. So as part of the growth and feedback portion of it, we're talking about the performance review now currently. The plan. Is there a set form the city has that we follow?
There is not. We're in the process of developing a performance eval form and building in those checkpoint meetings where you can kind of have an entire process. It's not just once a year you do this thing. So we're in the process of building it. We're going to be piloting it with a couple of departments before we roll it out citywide, but it's like top priority, and I'm like up to my eyeballs and I'm working on it right now. So as soon as we know, we'll be getting the announcements out and putting pilot groups through. And anything that we roll out on this, we'll have trainings for managers, and my plan is actually go to the departments and train you face-to-face in person, so there's lots of interaction since it's related to your industry fields. It's going to be very related to your job description, so it lets you ask questions from the perspective of your technical set of expertise in your roles. And then actually train the employees as well on their role limit, how they need to be keeping track of their documentation during the evaluation cycle, so that they know how to represent themselves the best when they get to the evaluation part. So we're going to be doing a whole bunch of training and rolling it out hopefully next year.
Yes, this form can keep us all uniform.
Exactly.
Hey, I'll put in a plug for the Chattanooga Improves. It can be a pain when you're really, really busy, but they give you a lot of good tools to use and kind of make sure you're having these one-on-ones with your direct report. They'll teach you about setting up a meeting, and that's a great time every other week or so to have a one-on-one with your direct manager. So we're about 3/4 of the way through it, but I've already had some conversations with my direct manager. It's a really good program. So when it comes, yes, it is a lot of extra things, but it will give you a lot of tools in your toolbox to help you. And
This information,
Melanie's been there.
this information is good for the new folks going on board, looking for mentors that help us through.
That's one of the things Chattanooga Improves will do. They'll set you up a coach.
Session coaches, and then I'm working on, for everybody that's new, and we mentioned the manager supervisor training that everybody had to go through. We haven't had another iteration of that. We ran 3 rounds of it in March, April, and May of this year, but if you have hired since May or you couldn't go to one of the spring sessions, we haven't had another one. We're working on converting all of that over to virtual training so that you can do it on demand. And there are some pieces like the conversations piece that are much better done in person where you actually have a chance to workshop that information. So we're going to continue to offer those in a live format, but we're working on converting all of that over so that even as you promote people, they can jump into Oracle and they can actually take those trainings themselves and actually start building their skill sets.
Okay, the next one that we need to talk about is misbehavior and harassment. So you all as supervisors really set the tone for your department. You all are setting the tone for what flies, what doesn't, what is appropriate, what is not in your working environment. What can your subordinates say, get away with, what type of comments, actions, behavior. That is really up to you guys. they're looking up to you, and if you're not going to allow something, certain behavior, comments, language, you all have to be the ones that enforce that. We had a case where we were defending a manufacturing facility, and the situation was that they had some employees who were working on the floor. They were welders, and it was a predominantly African-American workforce, and one of the white employees claimed that he was being harassed by his African-American coworkers, and they were singing the Dukes of Hazzard song towards him and calling him a redneck and flying the Confederate flag, and a lot of other comments were being made towards him. And so he complained to his supervisor. His supervisor brushed it off, said, there's nothing that I can do here, it's just how it is, working out here in the floor, it's just the environment where we are. So he continues to work there, and a few months later, he complains to HR. And again, HR looks into it, asks questions, and says, this is just the type of environment where we are. It's a manufacturing facility. There's nothing that I can do about it. So a few months later, the company did a company-wide reduction in force where they laid off multiple employees. And that one employee who had complained was one of the individuals who was caught up in the reduction in force. He was terminated. And when we spoke to the HR director during the course of our investigation, we said, did you ever know about this? And he said, yeah, of course I knew about that, but that's just the type of environment that they were working in. That was accepted behavior, and if he couldn't deal with it, then he needed to go work somewhere else. Well, I'll just tell you guys, that's a terrible defense to a legal claim, and that did not get us very far. So that was just one terrible example of the boys will be boys mentality. Another case that we had, again, was in a manufacturing facility where we had a female employee who complained about being harassed by her male coworkers. She said that she was being subjected to some sexual comments and maybe some touching, and she reported that to her supervisor. Again, supervisor didn't do anything. She reported that up to HR, and HR, again, didn't investigate. Well, HR did investigate, and during the course of that investigation, they found that the female employee who had initiated the complaint was actually also engaging in some inappropriate sexual comments towards her male coworkers. So when they did that investigation, they found that she was using vulgar language in the workplace, and they fired her for that use of vulgar language. The same language that the male employees were using towards her, she was reciprocating it and saying it back to them. So she was terminated, they were not, and she filed a complaint of discrimination in federal court because she was being treated differently than her male coworkers. And the defense that HR had was, well, boys will be boys. It was fine for them to say it. It was not fine for her to say it. Again, terrible, terrible defense. That did not go very far, and they did not win that case. So all of that to say is you all are the ones that are setting the tone. You all are the ones that are accepting what is appropriate to be said in the workplace. Who can say what, who can act a certain way, that all is up to you guys. So think about it whenever you hear something that's being said. Do not put your heads in the sand. I get this question sometimes also from managers, and they say, well, I kind of just don't want to know. I just, walk away from it. If there's ever a conversation, if I hear someone start saying something, I just walk away. I said, no, that's not good either. If you know about it, or you should have known, then you need to step in. And if you don't feel comfortable as the manager to step in, then you need to talk to HR about it. You need to be able to have those hard conversations with your employees so that they know it's not acceptable. Yeah.
Some people take things totally out of concept, and who is to determine of what the meaning is about whatever you're talking about?
Do you have,
That's happened.
so he said a lot of times people take things out of context. And how are we going to determine the meaning of what someone,
Well, some people might take it that you meant something discriminating against him or her, and in all actuality, you're not doing that.
so if someone's taking something in a way that they feel is directed towards them in a discriminatory or harassing way, then their feelings are still valid, and we have to have a conversation with both individuals in that situation. So we have to have a conversation with the individual who might be saying the thing that is discriminatory, or even if they don't mean to be, to let them know that that's how it's being taken. But then also have the conversation with the other individual employee and explain the situation. And that's your responsibility as a supervisor to figure out where's the miscommunication happening and how can we connect that and fix that bridge. Any other questions on harassment or misbehavior? Yeah.
When does misbehavior or jokes?
When it's based on someone's membership in a protected class, usually. So if we're just joking about someone, teasing someone for being an Alabama fan, then that's okay, we can let it slide. But if we're teasing someone and using racial slurs or sexual innuendos or leaving someone out because of their age or because of their national origin, then that's when we get into that discrimination or hostile work environment. Yeah.
New hire orientation, what we train staff on is that with harassment and discrimination, there's a definition of severe and there's a definition of pervasive. So severe is something that is at a level that is so bad, and pretty much if it involves physical contact, it almost immediately elevates it to severe because there's physical contact with a person. If it's severe, it can happen only one time, and that's bad enough. Whereas pervasive may mean it's not at that same level, but it happens here and then again and again and again and again, but where all of those accumulate, and that's a pervasive present pattern of harassment or discrimination. Either one of those are basis for somebody to file. Either a pervasive situation or something that is a severe situation.
Yeah, I mean, that's a good point, a reminder of severe or pervasive. So if you have a situation where someone is constantly being told, like, commented on their looks, like, you're looking really beautiful today, I really like that shirt on you, it's really flattering. If that happens over and over again and the individual is feeling uncomfortable with it, that could end up being something that is pervasive. It's happening every day in the workplace, making them feel uncomfortable, comments that are sexual in nature, though there's no touching at that point. But a harassment claim that is severe could just be that one-time assault. And it doesn't have to be, this is also important to note, is that it doesn't have to be on site at the workplace. So the creation of a hostile work environment could be a result of anything that occurs outside the workplace during happy hour, online, social media, if it permeates into the working environment, if it is impacting an individual's ability to perform their job, then that could be a creation of a hostile work environment. We had a case one time where an individual, two individuals, a male and female, they were friends, coworkers at the workplace and had a friendly relationship. It was an older gentleman and a young single mom, and she thought that they were just friends. He thought that they were building a different type of relationship. And so when he found out that she was seeing another coworker, he became enraged and he followed them home, followed them to Walmart, followed them everywhere where they were going, and to the point where she had to get a restraining order against him. Now, there was nothing that he was doing in the workplace at that point. It was everything that was occurring outside after hours because he was following her. But that behavior, even though it happened after hours, still affected her in the workplace. It still impacted her ability to do her job because she was expected to work with him in one-on-one settings. And she no longer felt like she was safe and felt comfortable doing that. So he created a hostile work environment at that point for her because she wasn't able to continue to perform her job responsibilities. Yes.
This is a fascinating topic. Thank you for answering the question. So this is a question for HR too. So if there's things that, hypothetically, if something unprofessional that happens in the workplace, but doesn't seem like harassment, or I haven't been at the city long enough to know if something is pervasive, and I want to get ahead of something, if I reach out to HR, what does that set in motion? What would be the follow-up actions after that?
You can always reach out to HR. One of the things we tell them, and part of the reason I'm bringing this up, that we tell them this in orientation, is trying to let you know that people who are coming onto your teams, they have harassment training as part of their orientation cycle. So that they know what their rights are as employees, they know what harassment looks like, they know what the workplace violence. You know, when we say zero, we mean zero. There's zero tolerance, and if you participate in these behaviors, you're going to be subject to disciplinary action. You can go to your HR business partner at any time with any type of situation that you've got. And one of the examples that I use in orientation is a picture of a woman reading a report, and there's a guy behind her, you know, zooming in and taking a picture of her. She's completely unaware that that is going on. If you see that happening, even though the person who's the victim of it doesn't know it's happening, you should still report that, because that is not the kind of workspace that we're building. That's not the environment we want to build. So if you know of something, you're like, I'm not really sure this is pervasive, but this looks like it's out of bounds, and I don't know how often this is happening, contact your HR business partner, make a report, let them know what's going on. You can either send an email and copy yourselves, or, you know, if you send it, then they'll have their own copy. Just reach out to them directly, and they may call you up and ask for more information. And it may be something that if it's happened enough, they'll say, you probably need to file a complaint so this can be a formal investigation so we can look into this. But you can report it whether or not you are the direct victim of it, or whether or not you just witnessed it happening in the workplace. Does that help?
Yeah, I think it helps. Are the people that one may have concern about, are they notified?
If you make the report,
Is it a formal report? If I'm emailing, is that legally like a formal report?
Mandy, who's our CHRO, she will start an investigation on the email. She considers that at that point we report. And all of you as managers, one of the things, and I think you'll go over this later, is if you know something's going on, then legally the city knows. Because you are in a managerial role and you're a mandated reporter and you have an obligation to prevent, address, and report situations that fall into these legal areas. So if you make a report, let's say it's person A is harassing person B, or it seems that way to you, and you're saying if I email my HR business partner, are you saying does person A find out or does person B find out? Either one?
Yeah.
Okay. If they're just talking with you to get information, that information may not necessarily make it to person A or person B. If it opens up an investigation, then they're going to start calling in witnesses, and that typically includes whoever might have been involved in that or witnessed that, and yourself and other people as well as the person who is the subject of the investigation also gets interviewed, because we're not going to interview everybody else but the person being accused of it, right? That's why we do things in this country. So everybody can get involved. It can be just one thing, if you want to go on the record and say that. If it turns into an investigation, then multiple people get notified. But remember too, that the investigation process here at the city is supposed to be confidential. That means if you're called in to testify or to participate in the investigative process, that's confidential between you and the people doing the interviews. It's supposed to stay confidential, meaning you're not supposed to talk to other people while the investigation is going on. And then if there's any retaliation because you participated in an investigation, you report that as a separate complaint, because it's a completely separate violation. And I'll say up front that Daniel, who's our deputy chief, says that he feels that retaliation is almost worse than the original offense, because retaliation is a premeditated, deliberate thing. You can accidentally cross a line in a harassment or workplace violence situation. So you know what, I really wasn't aware that this kind of crossed the line. You might still end up disciplined for the action, but there is an area that there's kind of the possibility of an I don't know. With retaliation, there is no possibility of an I don't know. So you need to make sure that you report that separately.
With retaliation, I mean, is that, I know there's some very clear examples, but basically, is there a fine line between still trying to be a manager with constructive feedback and performance, conversations that aren't going well? Can that be considered retaliation for a previous type experience?
If you will hold that,
Okay.
the very last slide that she goes over talks about retaliation because it's so critical.
Yeah.
So hold on to that so we can come back to that in depth. Did anybody else have a question about making reports about harassment and things like that?
I actually have two questions. First piece, I'm harassed. Do I have a say in what occurs? So let's say I report straight to HR, but I say, hey, I don't want them disciplined. I just want it stopped. I want them to have extra training. Do I have a say in what occurs?
That's a really good question. I may have to get back to you on that. I know that when we open an investigation, as HR business partners, we're typically in the driver's seat for like doing the investigations and compiling the information. We only make recommendations as far as discipline. Our goal with HR is making sure that this is a safe place for everybody to work, and that when you come to work, you don't feel like you're going to be harassed, that you can come here, perform your job, earn your living, be safe and happy being here. And so we're going to make sure that that environment that created that situation gets corrected. We make recommendations as far as what the discipline needs to be, but it's up to the departments and the managers to say exactly what discipline is going to happen.
And from a legal perspective, I would say that we're walking a difficult line there because we're going to be treating people differently based on what your request is. If you're the one who was being harassed and you say, I just want you to have a conversation with them, and during the review we find out that what they did was a terminable offense, they're probably going to get terminated, or at least they should from a legal perspective, so that we don't have to worry about them doing it again, and so that we don't have to worry about someone else coming in and saying that they were treated differently for the same type of action.
Yeah, consistency is huge. As a manager, it's one of the hardest things to do, but it's also one of the most important things, is that you are consistent across the board with everybody.
But shouldn't you talk to the individual before you go that far?
You don't have to. I mean, a lot of times,
Why would you do that though? If you can talk to the man and correct the problem, why get him fired?
well, I think a lot of times the situation is that the individual who's being harassed doesn't feel comfortable having that conversation with the harasser. So sometimes if you can't and you don't feel comfortable with it and you're worried about retaliation, then it does need to be reported outside of that chain of command.
I'm sorry, but I'm used to working in an entirely different environment, totally. I'm from old school, and if you had a problem with me, we'd take it out back, we'd take care of it, and it never went to HR. It was just a good old country butt whooping. Whoever won the argument. But stuff like this is, some of it seems like a lot of hogwash to me. I'm sorry, but it just does.
Just that the process of going to HR,
Yeah,
that's just, it's kind of
yeah.
like not the direct route of handling the situation. It's going around and getting a whole bunch of
Yeah, it's just a bunch of, it's just, I mean.
Well, think about it this way.
If you could correct it, it's just like a kid. You tell him not to touch that hot stove again, and he feels the heat, he'll know not to touch it again.
Well, that's HR. They're going to be the ones giving the butt whooping and like the hot stove.
Why not doing that yourself instead of going that far?
Not
You know,
everyone
if
feels that they can
keep
do
on
it.
having problems with it, yeah, I understand that.
Yeah.
Take it further, but a lot of things can be handled differently, I think.
Well, and I think it's different too. Like, for example, if someone were to make a sexually advancing comment towards me and I didn't like it, my first step would be, please don't do that again. I don't like that and I don't appreciate
Right,
that.
exactly. I
And
agree.
if that fixes it,
Great.
then as far as I'm concerned, it's
And
done.
if it don't, go do
Then go
something
to
else.
HR.
That's
However,
what I
let me give you some backstory. So different.
Mhm.
Let's say that I'm the same person and I'm sexually harassed by somebody. And I have a history of childhood sexual abuse,
Okay.
where I don't feel like I can speak up for myself because it's just gonna bring it down worse on me. And you don't know that I had that background. That person may never speak up directly to you and say, hey, please stop. And that's one of the things is that everybody that comes into work, you're seeing about this much of them every single day. You know the iceberg mentality, if you see 10% and there's another 90% below the surface? As a manager, when you come in and you're working with people, you're seeing the 10% that they bring to work. What you're not seeing is the 90% that lives below the surface. That's everything that went wrong this morning. That's the mother dying from cancer. That's all the childhood trauma they've experienced. That's losing their spouse. I mean, there's all kinds of things that are happening below the surface. Does it affect the 10% you see? It absolutely does. Do you necessarily see it or know it? You don't necessarily, but it's still affecting the 10% that you see. So in situations like that, where you're like, why don't they just tell me directly? Why don't they just handle this person to person? Not everybody's coming to the table with the same comfort zone, the same courage, the same capacity, the same faith that it's going to be fixed. Everybody's different. So having these avenues where people know they can go report it, know they can have somebody on their side, know they can have somebody in the room listening to them where it's not directly confrontational, sometimes that's absolutely necessary. So it can be either one. We want to know in HR because we don't want anybody at the city feeling unsafe or harassed or feeling like they're in danger coming to work here. Does that happen? Does everybody address it going through HR every single time? No, they don't. But as managers, if you had somebody come to you and say, hey, somebody harassed me, this person on our team harassed me, I don't feel comfortable talking to them. Would you tell them, well, you just need to go say something? Or would you get involved as a manager and say, okay,
I would
I'm looking
definitely
into
say
this?
something. I sure would.
You would look into it though,
Yes, I
right?
would.
You wouldn't tell them to go,
I would go look into it, and I'd get both of them's story.
exactly. So
But-
it's really no different with HR. If
Yeah.
somebody comes directly to us, we're looking into it.
But I can fix it right there without firing somebody, hopefully, you know.
It
I was
depends
raised-
on
I
the
was
severity
raised
of the
up-
violation.
I was raised up to respect women and respect others if they deserve respect. I work with a bunch of, I don't know if y'all know what millwrights are, but I've been a millwright all my life, all my adult life, and there's some rough characters. We don't have women at all.
Well,
So,
and remember to,
sexual harassment didn't exist.
well, remember that rules and laws and procedures that we have here, they exist not for the people who follow them, they exist for the people who don't. And we have to have those things in place to ensure that everybody's playing on the same field by the same rules, and so that we do make sure that we preserve this environment that we're trying to build and keep it the way it is. So I understand what you're saying from your background. It's hard to understand, and why this looks like a whole lot of extra, but there's a reason for all of this extra.
I understand the reasoning, I do, but I'm thinking, handle it here instead of handling it there. You know, if you can, but if you can't, I understand, that's what the HR is there for. So,
Well, and what I was gonna say is maybe a little more direct answer to what you're asking, purely from your end, is the civil liability of the actions. Anybody can basically sue for anything if the city doesn't take the right actions. Those dollar amounts can climb, and the city doesn't look to pay out on anything if they don't have to. So they have to address it a very specific way within the laws, or they accept the civil liability that goes with it, and then unfortunately that young lady has to defend that for the city, if it's even defendable.
if it goes that far.
Yes,
Sorry for all the questions.
they're good. I like them.
You're the experts. Are there any topics that are just completely off limits in the workplace, or is it like how you talk about a topic?
Do you cover that in other slides? Are you jumping ahead?
I don't know if I cover that specifically, but I do have a situation. We had a case where this happened. I will use my own personal experience, and I say all of you probably have that own personal experience where there are some things that you'll talk about with one coworker and other things you won't talk about with the other. Same like you might talk about some things with your sister or your mom, but not your dad. So think about that whenever you're having those conversations. But We had a case where a male supervisor had a female subordinate, and he found out that she was gay, and he said that he was an older gentleman, and he said, oh, I've never met a lesbian before, tell me about it. That made her incredibly uncomfortable because she's in this situation where her male supervisor is asking her just open-ended questions about what it's like having a same-sex relationship. I would say that conversation was probably off limits, or it should have been, and she agreed when she filed her lawsuit against the employer. So, I mean, I wouldn't say that there are really taboo questions. I mean, sex, religion, race, those are all things that can get you in trouble. Politics can get really heated. So, the things that you don't want to talk about at a dinner party, you probably don't want to talk about at the workplace, but you might get away with it with one coworker, but maybe not another. So especially when you're in that position as being the supervisor and you're talking with a subordinate, I would keep it, dinner table conversation.
Focus on the job.
Yeah.
Focus on your other. And there will be times like we were mentioning, like you just talk it out with the person, you just say what you gotta say. Anytime you are having a conversation and it goes over the line, it's like my comfort zone and your comfort zone. The minute you say something, somebody looks like they're not comfortable anymore, or they say to you, I'm not comfortable, stops right there. Because they've voiced it. They voiced it. And even if they haven't voiced it, but you're noticing, no, they're not being very forthcoming. They're shutting down. They're turning away. They're trying to get out of this conversation. Read the room. Read the room.
And we still need to document even conversations
It's a
like
good
we're
idea.
talking about, just for your own
As a
records.
manager, it's a good idea to document. You have a question?
Yeah, that second question I was saying, what's the delineation between sexual harassment and sexual assault? And then do the reporting requirements or actions change?
Assault requires physical contact, correct?
Right. So like on the video at the newcomers break, that was one where the guy smacked the female on the behind.
But also a creation of a hostile work environment right there. So we have assault, but we also have a sexual hostile work environment as well. Even though it was a one-time action, it was severe.
Yeah, and remember, Ryan, if you've been through your heart orientation recently, Ryan Ewald talks about the front page rule. Is the conversation you're having or the thing you're about to do or say, if that were to end up on the front page of the newspaper, is that a good day or a bad day for you and your mama? And if it's a bad day, you might not want to do or say that thing. And that actually will keep you out of trouble a lot of times, is using that front page rule before you do or say something or send that email.
We use that example a lot as well, whether or not it's something that could upset a reasonable person. Well, who is that reasonable person when you're looking at a hostile work environment or a harassment claim? Think about what you're about to say and whether or not you want it to show up on the front page, or if you would say it around your family, your kids, your parents, your spouse, or if you'd be comfortable with it being a text message and me using it as Exhibit A in front of the jury and going through and letting everyone read all of those text messages and all of those emails that you've sent about someone. Because something else to keep in mind when we talk about litigation is litigation has become so document heavy over the past 10 years, and that includes your text messages and your emails. So if you are texting about something that is occurring in the workplace, your phone is fair game. If you're emailing about something in the workplace, all of your emails are fair game. So I'm going to be looking at not just your text messages with your coworkers, but probably also your text messages with your family members, because you're texting on your way home saying, I can't believe so-and-so did this again at work. You're complaining about your coworkers. And so now all of your conversations could be potentially relevant. So I have to look at photos. I have to look at your notes, if you keep notes on iPhone, emails, everything. So keep that in mind whenever you are talking about someone or something that could be potentially discoverable in the future.
I'm going to go back to your previous slide about setting the tone with the voice will be voice thing. So a little bit of geometry, you have point, circle, sphere, right? Those are the 3 dimensions of point, circle, sphere. Whatever's at the center of the circle replicates at the outside of the circle. You are the center of your circle. Whatever you want your environment to be for your team and the expectations for your team and the conduct of your team, you set that at the center of the circle. If you're not setting that at the center and you're seeing all of this other stuff happening on the outside, are you tolerating what doesn't fit what's at the center? Are you setting the example that you're wanting to see at the outside? Are you getting that at the outside? All the way as far, because a lot of people here are pretty high up in management. You've got managers reporting to you too, right? So it's not just you setting the circle for your managers, it's can you see the behavior you expect in your department all the way at the farthest end of that supervisory chain, the people who don't supervise anybody. And if you can see that, then you've created a good climate because everybody knows what's expected of them and what you expect of them. So that's something to keep in mind and think about is, am I setting the example that I want my team to meet? And if you're not, that's a good place to start making some course corrections. Good.
Good questions.
You're making up for all the questions at the other sessions, didn't you?
Okay, so I think we've covered misbehavior and harassment, so we can move on to your improper response to employee leave requests, and I'll kind of run through these quickly. Okay, so most importantly for you all to know, we talked about the FMLA and the ADA. FMLA is if an employee has a serious health condition, and the ADA is if they have a disability, and the two can sometimes overlap. But that is not for you all to know, or it's not for you all to figure out. It's not for you all as supervisors to determine if someone has a disability. It's not for you all to determine if someone has a serious health condition. It's not for you all to determine if someone is eligible for an accommodation or eligible for leave under the FMLA. That is what HR is for. So if you have someone who's coming to you and saying, I need to be out for the next 10 days because I'm having surgery, you just say, okay, great, go talk to HR. They'll figure it out, they'll help you complete the paperwork, and they'll handle it. You all, as supervisors and managers, do not need to be involved in the day-to-day of the medical needs or medical leave of your employees. Same with disabilities. So if you have someone that's coming to you and saying, I'm having a really difficult time remembering everything that I need to do. I keep missing, 5 out of the 20 things that are on my checklist every day. That might trigger something in your mind that says, okay, maybe this individual has a learning disability, so maybe they need an accommodation, but I'm going to direct them up to HR so that HR can address that with them, and HR can figure out if this individual has a disability and whether or not they qualify for a reasonable accommodation. So that's just really all you guys need to know about ADA and FMLA is the less you know, the better. And that's same with HR. They don't want to know a whole lot either. They outsource all of the FMLA requests themselves because they don't want to be involved in it either. So just keep that in mind. But you do have to at least have a little bit of knowledge to understand when someone comes to you and says, I'm having a difficult time doing X, or you're noticing that they're not able to stand for their whole shift when that's something that's expected of them. Maybe they need an accommodation so they can have a stool wherever they are. Direct them to HR and they can figure it out. But remember, keep this in mind also. If you know that someone has a disability, or if someone does have an accommodation, or someone has been out on FMLA leave, they still have to follow all of your same call-out procedures. So if you know that someone's out on FMLA leave, or they have intermittent leave means that they could be taking, 4 hours every now and then whenever they need it, rather than 12 weeks all at the same time. They still have to follow your same call-out procedures. So if you require someone to call out 1 hour before the start of their shift, they still have to do that with FMLA intermittent leave. You'll see that a lot with individuals who have migraines or some sort of neurological problem, maybe morning sickness. They might say, I know that I get migraines in the mornings, so I might have to call out first thing in the morning. They still need to give you that notice. I also don't want you all to think that just because someone has a disability or is out on FMLA leave that you can't discipline them, because you can. We had a situation once where a supervisor called me and said, hey, I have this individual who works on our janitorial staff, and he's been having some difficult time remembering everything he was expected to do. So we created a checklist for him as an accommodation, and he still just isn't doing everything on the checklist that he needs to be doing. So I think he's not a good fit for our department. I'm going to transfer him to a different department. And I said, well, have you had that conversation with him that he still isn't meeting expectations? And he said, well, no, I know that he has a disability, so I can't talk to him. That's not how it works. You can still talk to him, you can still have that conversation, let him know that it isn't meeting your expectations, because the one thing that you do not want to do, and that what none of you want to happen to you, is for a poor performer to just be transferred into your department. No one wants that. That's a terrible idea. So have the courage to have that tough conversation with the individual rather than just scooting them along to the next department. So you can still talk to them, just make sure that you're talking with HR as well. Yes?
Yeah, that is a tricky situation, and one that, it's very uncomfortable. You've got somebody who's been in and out of FMLA, has serious health issues, but is a constant poor performer. This has been potentially brought to HR, and this has been ongoing, documented since then. At what point do you bring that to HR? And I feel like some managers are worried that this situation may come to a head, right? Where it's looking at discriminatory based off their disability, if you will.
Yeah, it is really kind of a delicate situation because you want to make sure if you're looking at someone's performance, maybe they have been on and off FMLA leave, you're not looking at their performance of their attendance. You're not saying, well, this person is never here, so they're clearly a poor performer. Because of course they're not here, they're out on FMLA leave, they're on job protected leave. But if you're telling me that when they are here, that they're not doing a good job, that they're not actually performing their responsibilities, then that's a different conversation, and definitely something that you should be documenting, and then something that you should be addressing with HR as well, so that HR knows and HR is able to handle that conversation rather than you as the manager having that conversation with them.
You want to say something too. So FMLA, and I can stay after and answer questions on FMLA for people if you have extra ones, but FMLA is not just open-ended leave. There's a certain amount that they get every single year. It can be continuous or intermittent, like all in one block or taken bits at a time. They only get a certain amount. Once they've used that amount up, it's gone for the year until they roll around to that 12-month mark, and then they can file it again. It's not something where they can just be out whenever they want to. They still have to follow calling procedures. If they're on intermittent and it says they've been approved for 8 hours 2 times a month, and they're taking 8 hours 6 times a month, they are now outside their approval and they have to go through the reapproval process for those extra days. So it's not just a carte blanche for them to just run over your department. And if you end up in situations where people are working the system, or you suspect fraud, like they say they're on FML, and they can't even work, but they're out partying and posting it on Facebook. There's situations like that where that edges over into fraud. So best thing to do is if you have any concerns about that, get your HRBP involved early. You can always call Starla. We have had people investigate situations where people are supposed to be on FML and weren't necessarily on FML. So we can look into it that way. But also remember that when people are out, it affects your team. And if you've got somebody that's on FML and they're just out and they're out and they're out, and it's almost like that position hasn't been filled, then you run into problems with all the work flowing over to the rest of your team, which is unfair. And then you also run into problems when you get to the end of your budget year, and you've operated without that person being here for 10 months. Are you sure you need that position? And you don't want that situation to happen either. So suggestion is get involved with your HRBP as soon as possible with those situations. talk to Starla, talk to your total rewards benefits team about, because we can look up in our third-party administrator what they filed for. Now, we don't necessarily know why they filed, but whether it's intermittent or continuous, we can look and see when it was approved, we can see what their end date is, all of that stuff, to where you're not just being held hostage by, oh, this person's on FML. That's not the way that's supposed to work. FML is there to keep people from losing their jobs because stuff happens that has nothing related to work. But it's not there to be abused either. And if you're in a situation where you feel like it's being abused and it's impacting your team, we can take steps forward to figure out how that, now I'm not saying it's necessarily fast, because we have to be careful to make sure that we're not violating any laws or something, but it's not like our hands are tied here. So the sooner you get your HRBP involved and the benefits team, the better.
Yeah,
I
question?
was just gonna ask, if somebody's out with PTO, does that count towards their being at the city for a year?
So like if does a PTO day count as one of the days towards that full year work? Yes, it does.
Yes.
Because that's an equivalency. So like if I'm here and I earn vacation time and I use all my PTO during that year and I come around to my 1 year mark, it still counts as a 1 year mark.
Yeah. You just have to make sure that they've worked their 1,250 hours.
So does that count towards the 1,250
Yes.
hours?
We count towards, the whole thing I believe counts. And that also means that if you have part-time people that are working 25 to 30 hours a week, a standard full-time year for a person working 8 hours a day, 40 hours a week is 2,080 hours. So anytime you get over like 25 hours a week, there's a good chance they're gonna hit that 1,250 hour threshold, even if they're part-time. They still have to meet the 1 year requirement.
It has to be both.
It has to be both.
Good questions. Okay. Inconsistent policy enforcement. This is another issue that we run into a lot. So we have the situation where we don't want to be honest with our employees, we don't want to be hard on them, but we also have the situation sometimes where we favor one employee over the other. And we want to make sure that we're treating everyone consistently and not inconsistent policy enforcement. So I have two clients, one of which does a really good job of this, another one who does a terrible job at this. And the first one, they keep a spreadsheet of every time there's a policy violation with every person's name on it, and they say the date the policy violation occurred, the offense or occurrence number, and the individual's name, and then the outcome. So if it's the first time that someone's late, more than 10 minutes late, then they just get a verbal conversation. And then the second time, they might have a written warning, and then the third time, they might have some other accelerated discipline. But they're keeping a list of it, so that every time we have a situation come up where someone has done something, whether it's within the handbook or not, we're able to look back and say, all right, this is how we handled that situation when it's someone's first or fifth offense. On the other side, we have another employer who does a terrible job with this because they don't keep track of anything and they just inconsistently enforce the rules depending on who the supervisor is, depending on who the employee is, how they're feeling that day, which side of bed they rolled out of. You just never know what you're going to get. And that leads to a lot of complaints of potential discrimination. Because that's what it looks like. It looks like someone is being treated differently based on their race or based on their sex, and it's some sort of favoritism that's occurring in the workplace. And so we have a lot of issues where we're combating these complaints of discrimination that wouldn't be there if the employer would just enforce those policies the same across the board. So if you know that you always write someone up after their fifth time being tardy, go ahead, do it. Even if you know that that person had to stop and get cupcakes for their daughter's birthday in the morning, you need to make sure that you're treating everyone the same so that we're not running into any situations of potential discrimination. All right, proper investigation or not. This is something I think we've kind of talked about already today, but I will preface all of this with saying I hate the word investigation. It looks like, to me, it's like big, scary eye investigation, like the police officer has you in the interrogation room with like the light shining in your face. And that is not what we're trying to do here from the supervisor level or from HR's level. It's really just fact-finding. We need to figure out what's going on, have conversations with the individuals who were impacted, and determine whether or not, from your level, it needs to be escalated to HR, or if you can handle it, like you talked about, maybe just at the supervisor level. So I've had a few situations where investigations can go one of two ways, and how do you know at what point you need to make it a big, scary, capital I investigation? Well, we had a situation one time where an employee complained about their HR director to the CEO. She sent an email to CEO and said, I think the HR director is being a bully, she's not being very responsive to emails, and I think someone needs to look into this. So the CEO called me because she couldn't call the HR director at that point and said, what do I do? Do I have a conversation with the individual? Do I have a conversation with the HR director? What does this look like? I said, well, at this point, we just know that HR director might be a bully. So let's get some additional information from the person who complained and then have a conversation with the HR director and see if we can't work this out. Because there are no triggering words in that email at that point. There was nothing that said anything about discrimination or harassment or being treated differently based on my membership in a protected class. Said, this is pretty straightforward at this point. Just go talk to the individual who complained. She said, okay, great. Well, during the course of that phone call, the CEO received 4 more emails from different employees complaining about the same HR director. And they all said different things, and some of them used some of those key words, such as discrimination. And at that point, that was an escalated incident. And I said, all right, at this point, we need to talk to all of those individuals, but it doesn't make sense as you, the CEO, to be the one to do it. It makes sense for someone else to step in and actually have those conversations and see if there's any basis for these claims of discrimination. So from your all's perspective, as supervisors, you might hear things in passing. You might hear someone yell something out in the middle of the hall, or you might hear a rumor about some sort of incident that occurred, whether it was physical or verbal, something that's going on between 2 employees. How do you know what to do? And how do you know at what point how to escalate it? Well, if you know of something or you think you know of something, then the city also knows. And at that point, if you have knowledge and the city has knowledge of a potential claim of discrimination or harassment, then we could be in a situation of liability. Because once you know, we have an obligation to act. So just because you want to sit in your office and close the door and say, well, I don't want to know about these rumors, I'm going to turn my ears to this, then it doesn't mean that it didn't happen. So you all do have that obligation to first talk to someone else who's in your department. Go talk to the person who is making the complaint, or talk to the person who might be a victim of the discrimination. See what they have to say about it, and if their claims are substantiated, or it sounds like there is something that's actually there, then you can escalate it to HR. And HR at that point can step in and figure out who else in your department needs to be spoken to, because they're the ones who are going to do the fact finding, and they're the ones that are going to figure out where that investigation needs to lead. Any questions on proper investigations? We talked about this a little bit just a minute ago when we were talking about medical restrictions and accommodations, but if you have an individual who is requesting light duty work, or someone who is out on FMLA or requests some sort of leave, don't just automatically say yes or no. We defended a case one time where the supervisor received a request from a female employee to take off every Friday for kind of the indefinite future because she was undergoing chemotherapy treatment for breast cancer. And the supervisor wanted to be understanding and accommodating, and he just said, yes, of course, like, if you need to take leave for chemotherapy, I, of course, understand that. Please take whatever leave you need. Well, a few months went by, and he got kind of fed up that she was never there on Fridays. It was like he totally forgot what had happened. And he became frustrated that the rest of the team was picking up the slack for her and that she wasn't there on Fridays, she wasn't working, and when she was there, she kind of seemed tired, she wasn't really with it. And so he went to HR and said, I think we need to go ahead and terminate her. And HR said, okay, well, that makes sense. If she's not a poor performer, go ahead, we can separate her. HR at this point had no idea that this individual had breast cancer and that she was going through chemotherapy treatment. Had they known, they would have given her FMLA paperwork. So don't just make the first reaction from you all being yes or no when someone requests leave. Bump it up to HR. Let HR figure it out because they're the ones that are going to know whether or not this is a qualifying disability or a qualifying serious health condition, and someone needs to be out on FMLA paperwork, and they'll get that paperwork for them as well. But I also want you all to think about what you're saying to your employees. If you have someone who says, I get really bad headaches in the morning, or I get really bad migraines, I can't come in until 9 sometimes. Don't respond with, well, everyone gets those. Everyone gets a headache, just work through it. You can work through it, it's not a big deal, just come on in. Because if that individual does have a migraine or they do have cluster headaches, then that is a qualifying disability. And if you're telling them that you can't accommodate that, then you're setting yourself up and the city for a potential claim of disability discrimination under the ADA. So again, if someone's telling you that they need to come in a little bit later, bump it up to HR so they can handle it for you guys. All right, the biggest one that I hope you guys can take away from today is retaliation. Because retaliation, as Melody mentioned earlier, is the number one issue that we run into in litigation and where courts are least likely to let us out of cases. Because while there might be an incident where you slip up, something discriminatory or harassing occurs in the workplace, if your reaction is to retaliate against someone, that is intentional behavior. So if someone comes to you and complains about some sort of discrimination or harassment in the workplace, and your response is, I can't believe they did this to me. Now I have to fill out paperwork and I have to go talk to HR. I don't want to deal with this. I'm just going to go ahead and write them up for their poor performance and terminate them for whatever made up reason you can come up with. Then that's retaliating. You're treating someone differently and acting out against them based on their engagement in a protected activity. So the definition is if you're reasonably dissuaded an employee from complaining. One of the cases that we represented a client in was a claim of sex harassment in the workplace. The individual complained to her supervisor that she was being discriminated against and subject to a sexual harassing environment. And her manager's response was, okay, well, they were in Lexington, Kentucky, said, okay, I'll move you to the Louisville office. And her response was, that's like over 2 hours away. That's not really what I wanted out of this. So she called corporate HR and said, I don't want to have to move to the Louisville office. I want to just continue working where I am. This doesn't seem fair. Corporate HR said, you're right, I agree with you. We didn't know this was happening. So let us move you back to Lexington, investigate this, and figure out what's going on. She gets moved back to the Lexington office, and her manager gets terminated because he mishandled the situation and he didn't have that authority to move her. The new manager that comes in was best buddies with the manager who just got fired. And he's annoyed that now his territory has expanded and he now has more employees that he has to supervise than he previously did. And he's angry at this woman for complaining and getting his friend terminated. So as soon as she returns and he's the new supervisor, this employee who had worked for the company for 10 years as an excellent star employee, never once had any sort of complaint against her, all of a sudden in a 1-month period had 4 disciplinary actions taken against her. And the next one, she was going to be terminated. So she resigns because rather than being terminated for that 5th one, which she knew was coming, she just decided to go ahead and resign. And when we were litigating the case, the sex discrimination and harassment claim, that was easy to get rid of. We were able to get out of that pretty quickly. But the retaliation was just so evident that there was no way we could get out of that one, because what the judge looks at is one of the elements is temporal proximity, from when the complaint happened to when the adverse employment action occurred. So as soon as she complained, within 1 month, she was receiving disciplinary actions, one after another, for things that she had previously done that weren't a problem, for things that other employees were doing that they weren't being disciplined for things that she had always had the opportunity to do. And so we're looking at a pretty bad retaliation claim at that point, and the judge wouldn't let us out of that one. Nope, got out of that. But that's what I want you guys to think about when you think about retaliation, because if you have an issue with an employee, there absolutely cannot be any retaliation, treating them any differently. And it's not just, oh, you're disciplining them or you're terminating them in response to their protected activity. It could be anything, such as not giving them the job assignment that they wanted, not giving them that raise, putting someone else on first shift that had been wanting first shift versus third shift. It could be a whole slew of things. It doesn't just have to be a termination. Did that answer your question from earlier?
Kind of. I think so much of it is situational, right? Yeah, because I guess the whole point is premeditated, right? I mean, if there's something done that has zero malicious intent, it's all about that person's interpretation, right? And then, to your point, it really just falls on the word of the person who feels like they've been wrong in that situation.
Yeah, and it goes back to that very first slide that I had about your legitimate non-discriminatory reason for doing something.
Yeah.
So what was the actual reason for not giving them first shift or not giving them that job assignment that they wanted? Was there something else that we can point to, some other documentation other than just, well, they complained last month and I'm really sick of them, so now I want to punish them to dissuade them from ever complaining again? And that's where it comes back to.
Let me add something in there too, because I don't think we discussed it earlier. So, let's say you have to write an employee up and you have to have a conversation with them because they're not meeting the bar in whatever way. And they're sitting across the table from you and they're like, you know what, I'm just gonna file a complaint on this. This is harassment. I feel like I'm in a hostile work environment. The typical way people feel is like, okay, we need to stop this conversation because obviously this is gonna go to HR and I just need to hold off doing this corrective action until we have a chance to look into this. That's not what you do. You tell the person, okay, you have the right to file the complaint. I'll make sure that I can give you the form after we're done, but we're still going to address this performance issue. And you proceed forward with the corrective action. If the corrective action ends up unwarranted, they can grieve it, and it can be undone if it was found that wasn't appropriate to do. But you don't need to stop disciplinary action because they're threatening to go to HR with a complaint or harassment or hostile work environment. That's a separate process. And as long as you have the documentation, you've been late 10 times in the last month. Whatever the issue is, if you've got the documentation and the consistency that we talked about earlier to show that this is not acceptable performance, you proceed with whatever that corrective action is, and the grievance or the complaint about Harassment and hostile work environment gets handled separately, that's a separate thing. That makes sense? A lot of people tend to think that you're supposed to back off, but really, you're empowered to go forward. If you've got the documentation that that's not performance that should be happening, and they're either violating policies or underperforming, you can still proceed, and that's not a harassing situation. Does that make sense?
So those are my 8 big things that I hope you guys can stay away from, to not have to see me again, or you can learn from other employers' mistakes. But if you guys have any questions, I'll stick around for a few minutes. I know Melody is also always available to answer questions. But thank you guys, really appreciated the good engagement and good questions.
So they have great questions.
Yeah, thank you.